taken a few decades and a lot of work and a lot of talking, but it has finally bubbled up and people have finally taken notice at the highest levels of American law.
The Supreme Court heard oral argument this morning, and it was fascinating.
About Hawaiian law limiting guns in places like shops, gas stations, and bars.
The state law dubbed the vampire rule prohibits people from bringing a firearm on private property open to the public without prior permission from the owner.
In a surprise to no one, the Ninth Circuit upheld Hawaii's law, and now the Supreme Court granted review, and the issue is being submitted after today's oral argument.
Now, Hawaii gun rights groups say that the current default ban is impractical.
Justices seemed likely to strike down a Hawaii gun law called the vampire rule.
The Supreme Court just dropped a bombshell that could change everything for gun owners across America. 2 hours of intense debate, 3 attorneys battling it out, and 9 justices asking questions that will determine whether millions of concealed carriers can legally protect themselves in public. What happened today in Washington, D.C. might sound like just another court case, but the implications are staggering. Hawaii has what's known as a vampire law, and no, it's not about bloodsuckers. It's about something far more serious, your constitutional right to self-defense. This law says that if you're a licensed concealed carrier, you cannot bring your firearm onto private property that's open to the public unless you get explicit permission from the property owner first. Think about that for a second. Every store you walk into, every restaurant where you grab a bite, every parking lot where you leave your car, you'd be breaking the law just by carrying your legally licensed firearm unless someone specifically told you it was okay. The case is Woolford versus Lopez, and after listening to the entire oral argument session, the dynamics in that courtroom were absolutely fascinating. 3 different attorneys stepped up to argue various aspects of how the Second Amendment applies to this controversial Hawaii law. As expected, the Ninth Circuit had previously upheld Hawaii's restriction, but now the Supreme Court has taken up the case, and what happens next could reshape gun rights nationwide. For those of you in California, this case hits especially close to home. There's a similar challenge to California's sensitive places law sitting at the Ninth Circuit right now, and that case has been put on hold specifically to wait for this Supreme Court decision. The California case was supposed to have a hearing in March, but everything's been stayed pending what the Supreme Court decides here. We're likely looking at a June decision that could have immediate ripple effects across multiple states. Let me break down what actually happened in that courtroom today, because the exchanges between the justices and the attorneys reveal exactly where this case is headed. Attorney Alan Beck represented the gun owners, and he faced some seriously tough questioning right out of the gate. Deputy Solicitor General Sarah Harris argued for the United States government, and in a refreshing turn of events, she actually took a pro-Second Amendment stance. Then there was Neil Katyal, representing Hawaii's Attorney General, defending the law. Justice Ketanji Brown Jackson threw out an interesting perspective that caught many observers off guard. She doesn't see this as a Second Amendment case at all. She frames it as a property rights issue. Her argument goes like this: if a property owner has the absolute right to exclude anyone from their property for any reason, then they naturally have the right to exclude people who are carrying guns. It's a clever reframing, but it misses a crucial distinction that became a major point of contention during the arguments. The confusion between truly private property like someone's home and private property that's open to the public became a recurring theme. Several justices seem to blur these lines, which is concerning because the rights and expectations are completely different. When you open your business to the public, you're inviting people in to conduct commerce. That's fundamentally different from your private residence.
The court heard oral argument this morning with 3 different attorneys arguing various aspects of how the Second Amendment applies to Hawaii's law.
First and foremost, basic gun safety does not have to be a threat to the Second Amendment.
The so-called vampire rule prohibits people from bringing a firearm on private property open to the public without prior permission.
And I think it's pretty simple, is that we want to do our due diligence if we're looking to give people gun rights.
Several of the justices made their positions very clear, but I think we'll get a win here when the decision comes out. Hopefully it'll be published in June.
A lot of what we hear this morning is trying to figure out what is our nation's history and tradition.
Attorney Beck dropped a stunning statistic that should make everyone pay attention. Over 96% of Hawaii is currently off limits for concealed carriers. That's not a typo, 96%. Between the web of sensitive place designations and this private property restriction, licensed carriers have almost nowhere they can legally exercise their constitutional right to bear arms. Justice Sotomayor pushed back on this number, pointing out that it includes state parks, government buildings, schools, and other places where the state owns the land. She argued the state might have different rights when it comes to excluding people from government property. While that's true, it sidesteps the core issue of this case, which focuses specifically on privately owned property that's open to the public. The historical analysis got particularly heated, and this is where things got really interesting. The state and Justice Jackson want the court to consider black codes from Louisiana in 1865 as historical analogs supporting Hawaii's law. Think about that for a moment. They're citing laws that were specifically designed to prevent newly freed slaves from exercising their Second Amendment rights. These codes prohibited black people from carrying guns precisely to keep them defenseless and vulnerable. Justice Thomas and the gun rights advocates forcefully pointed out that these laws were unconstitutional from the moment they were enacted. They're not valid historical examples. They're outliers that represent exactly the kind of discrimination the Constitution prohibits. Using unconstitutional racist laws to justify modern restrictions is a dangerous precedent that the court seems unlikely to embrace.
Those black codes prohibited black people from carrying guns precisely to thwart their Second Amendment right to self-defense.
We're putting an onus on small business owners, on mom and pop shops to keep out guns.
The U.S. Supreme Court appears ready to strike down a law that bans guns in places like restaurants, stores, and hotels.
Our citizens want gun safety, want firearm safety, want community safety.
Our side and Justice Thomas pointed out that those laws were unconstitutional from the start, and therefore they are outliers.
I know that sentence sounds fake, but apparently miracles do still happen in federal court.
The state also tried to draw parallels to old anti-poaching laws that prohibited hunting on private property without permission. Several justices expressed skepticism about whether these hunting restrictions are truly analogous to a blanket prohibition on concealed carry for self-defense. Hunting is about taking game from someone's land. Carrying a concealed weapon for protection is an entirely different matter. Justice Alito made a particularly compelling point that no other items are subject to this kind of blanket prohibition without express permission. You can walk into a store with a knife, a machete, or other potentially dangerous objects without getting explicit permission first. Why should lawfully carried firearms be treated differently? This inconsistency in how we treat different objects undermines the state's position. The comparison between First and Second Amendment rights created some of the most revealing exchanges. There was discussion about whether the state could prohibit political candidates from approaching people's doors unless the homeowner posts a sign allowing it. The obvious answer is no. Political candidates have the same right as anyone else to walk up to your door. This comparison highlights how we wouldn't tolerate similar restrictions on other constitutional rights. Justice Kavanaugh referenced the landmark Heller decision and its clear statement that the Second Amendment is not a second-class right. This is crucial because Hawaii's law effectively treats the Second Amendment as inferior to other constitutional protections. The disparate treatment between how we protect free speech versus the right to bear arms became a recurring theme that clearly troubled several justices. When Deputy Solicitor General Harris took the podium for the United States, her argument was remarkably strong in favor of gun rights. It's not often we see the federal government taking such a clear, pro-Second Amendment stance at the Supreme Court, and her presentation was both legally sound and persuasive. She faced questions that wandered off topic. Justice Sotomayor asked about carrying in churches, while Justice Barrett posed a hypothetical about prohibiting carry at gas stations during a crime wave. The softball questions from Justices Thomas, Gorsuch, Alito, and Kavanaugh revealed their likely positions. These justices seem firmly aligned with the gun owner's position, seeing Hawaii's law as an unconstitutional burden on the right to bear arms. Their questions helped Harris strengthen her arguments rather than challenging her position.
Justice Ketanji Brown Jackson, in particular, doesn't see this as a Second Amendment case, but rather as a property rights case.
Open carry has historically been regulated. The U.S. Supreme Court has said those types of regulations would be improper.
It said in part that gun regulations must be consistent with the historical tradition of firearms regulations in the U.S.
The gun owner's attorney, Mr. Beck, argued first and struggled with some tough questions from Justices Sotomayor, Jackson, and Barrett.
If you're going to restrict a constitutional right, it has to be consistent with the nation's historical traditions of firearm regulation.
You need to be on the right side of the law because the legal system is complex.
When Neil Katyal argued for Hawaii, He claimed there's no assumption that an invitation to enter private property includes an invitation to bring a gun. Justices Thomas and Roberts immediately challenged this premise. The idea that constitutional rights need explicit permission to be exercised turns the entire framework of our freedoms upside down. Justice Kagan tried to draw a parallel between First and Second Amendment restrictions, arguing that if a mall owner can prohibit leaflet distribution without consent, they should also be able to prohibit firearms. But Justice Alito countered brilliantly, a restaurant owner generally cannot prohibit specific shirts or clothing, so why should they be able to prohibit lawfully carried firearms? This exchange highlighted the inconsistent treatment of different constitutional rights. The discussion touched on California's law and how it differs from Hawaii's version. In Hawaii, verbal consent is sufficient to allow carry. California's law, which is currently on hold, would require property owners to post signs explicitly allowing firearms. This distinction matters because California's version is even more restrictive, making it harder for property owners to welcome law-abiding carriers.
In many of the questions, there seemed to be some confusion about places open to the public versus private homes.
Hawaii and 4 other states created similar concealed carry guardrails in response to a Supreme Court decision in 2022.
Well, the U.S. Supreme Court could strike down a Hawaii rule requiring gun owners to get permission before carrying a concealed weapon onto private property.
The fact that you have a concealed carry permit does not mean you get to go anywhere you want with your firearm.
Attorney Beck pointed out that over 96% of Hawaii is currently off limits for concealed carriers because of a web of laws.
It's not the gun owner, it's not the pistol permit holders, it's the criminals that are causing the violence and the gun problem.
Reading the tea leaves from today's arguments, the court appears to be leaning towards striking down Hawaii's law. Justices Roberts, Kavanaugh, Alito, and Gorsuch seem firmly in the gun owners' camp. Justice Thomas will likely join them with a detailed concurring opinion, diving deep into the historical analysis. Justice Barrett asks probing questions of both sides, but may ultimately side with the majority. On the other side, Justices Jackson, Sotomayor, and Kagan will almost certainly dissent. Justice Jackson's framing of this as purely a property rights issue rather than a Second Amendment case shows her fundamental disagreement with the majority's likely approach. Justice Sotomayor's comments suggest she'd overturn the Bruen decision entirely if she could, viewing that test as unworkable. Interestingly, Justice Kagan's position might provide some useful language even in dissent. She seems to believe Hawaii's law passes Bruen's first step, but struggles with the historical analogs required in step 2. This nuanced view could help clarify how lower courts should apply the Bruen test going forward. The implications of this case extend far beyond Hawaii. California's similar law hangs in the balance, and other states with comparable restrictions are watching closely.
Several justices don't seem to believe that this is sufficiently analogous to Hawaii's law.
People here in Hawaii decided this, and this is the way they want to live here.
The Supreme Court is expected to make a decision by summer. We just heard from the state AG's office that they believe the current law is constitutional.
Hawaii law limiting guns in places like shops, gas stations, and bars.
The Supreme Court case is especially important to California because of the challenge to California's sensitive places law.
U.S. Supreme Court today hearing arguments on Hawaii's strict gun law. The justice's decision could impact concealed carry laws.
The Supreme Court heard arguments today about a Hawaii law limiting guns in places like shops, gas stations, and bars.
A strong decision striking down Hawaii's law would immediately call into question similar vampire laws across the country. It would reaffirm that the Second Amendment protects the right to bear arms in public, not just in theory but in practice. We're also keeping an eye on another crucial case, Duncan versus Bonta, which challenges California's ban on standard capacity magazines. That case was redistributed for conference last week, and the court could grant review, redistribute it again, or deny review entirely. The timing of these cases could create a 1-2 punch for gun rights if the court takes them both on. The vampire rule appears to be on life support after today's arguments. The justices' questions and comments strongly suggest they see Hawaii's law as an unconstitutional burden on the right to bear arms. When the decision comes down, likely in June, it could mark another significant victory for Second Amendment rights following the court's landmark decisions in Heller, McDonald, and Bruen. What we witnessed today was more than just legal arguments. It was a fundamental debate about the nature of constitutional rights in America. Can states effectively nullify the Second Amendment by making it impossible to exercise in practice? Can property rights trump constitutional rights when businesses open their doors to the public? These questions go to the heart of what it means to have protected freedoms in our society. For responsible gun owners who simply want to exercise their constitutional rights while going about their daily lives, this case represents hope that the highest court in the land understands the practical implications of these restrictive laws. The 96% figure should shock anyone who values constitutional rights. When only 4% of a state is available for exercising a fundamental right, that right has been reduced to a mere privilege. That's it for today, folks. See you in the next video.